Are you an attorney and you're arguing for 100% disability in California workers' compensation for your client, but the defendant, the insurance company, is disputing the 100% disability and arguing for medical apportionment? There's a recent case that's come down that may be helpful to your argument. Hi, my name is Michael Burgis. I'm a legal certified specialist in California workers' compensation. I'm a trial attorney and the managing attorney of MB&A. Often I argue for 100% disability on cases, and there's a few ways that you can do this. But one is through medical evidence, and then one is through vocational evidence. And very often, the defense get confused between valid medical apportionment and valid vocational apportionment. And this case, called Vincent Helper versus County of Sonoma Health Services, helps shed some light on what that burden is. The holding on this case was the applicant was entitled to a 100% permanent disability award when they successfully rebutted the normal permanent disability rating schedule. And here it sounds like there was battling vocational experts, which is very common in my practice. And very often you'll see you develop the medical record, and that medical record will indicate what their impairment is, their whole person impairment, under what's called the AMA guides, or when it comes to psychiatric injuries, under something called the GAF scale. Now that's medical apportionment, and apportionment is due causation of disability per the Escobedo decision. So what happens is a doctor will rate the disability, and then they'll address what's work-related and what's not work-related, and very often there's some apportionment to non-industrial causation. I think in this case it was 15% of the orthopedic was apportioned to non-industrial. Now, medical apportionment is different than vocational apportionment, and this case highlights it very well. And this happens very often in my practice. So what I do is this: I make sure that when I depose all those doctors, I show that all of their work restrictions are solely being issued because of their industrial injury. And while they may have apportioned 15% to degenerative findings, orthopedically, the work restriction has no apportionment. Now, at the end of the day, what the vocational experts should do is they look at an injured worker, they look at their transferable skills, they pull all the medical evidence, and they pull out all of the work restrictions. They take those work restrictions, they plug it into some software to see, is there any job out there that they have the skills to do that are within those work restrictions. So one, as a practice tip for any applicant attorney or injured worker themselves, you want to get all the work restrictions you can across the board from every subspecialty, right? The greater the work restrictions are, the more likely your vocational expert will opine substantially that you are unable to compete in the open labor market. But in this case, there was medical apportionment. I'm guessing the defense vocational expert was therefore relying on that medical apportionment. But again, if the only thing the vocational expert should look at is the work restrictions, and they should not be taking AMA guide or medical apportionment into consideration vocationally. It's a separate analysis. And in this case, again, Vincent Helper v. County of Sonoma Health Services, the defense did not sustain their burden on apportionment. Again, it's applicant's burden to show injury, AOEC, that injury arose out of and was within the course of employment, and permanent disability, okay? In this case, they are trying to rebut the rating string by arguing that they are unable to compete in the open labor market based solely on industrial causation. And again, the burden shifts to the defense on apportionment, and it's their burden to show more likely than not, based on reasonable medical probability or reasonable vocational probability, that there's valid apportionment. And in this case, defense didn't sustain their burden, applicant met their burden, and the applicant was entitled to a 100% award. And I want to press this for the viewers who may not know this. Hopefully, if you're an applicant attorney, you're very well of this. There's a catastrophic difference between 99% disability and 100% disability in workers' comp. And we're talking sometimes 7-figure difference. So it's very important because most defense attorneys, when they are going to concede that somebody's 100% disability, the way they minimize or reduce their liability is to go looking for apportionment. Because if they can show that 1% of that, 1% of the inability to compete in the open labor market is attributed to non-industrial factors, well, now that's a 99% case, not 100, and they've saved their client 7 figures. If you're an injured worker or an attorney that's advocating for somebody you think is 100% disabled, and the insurance company is not conceding this. Of course, they never will, and they're arguing for apportionment. Give us a call. If you have questions, we have the answers. We're standing by. Also, if you found this video to be informative or helpful, please like, please subscribe below. We put out lots of content that's really here to help fight these insurance companies and their bad faith, failure to provide benefits, and really to help get justice for people who are disabled, especially those who are 100% disabled.